Good afternoon. My name is David Deal, and I want to thank you for attending this webinar intended to help your understanding of the new Los Angeles Hotel Worker Protection Ordinance that was signed into effect July 7th by Mayor Eric Garcetti. I'll be moderating this event. The ordinance has several aspects that can be difficult to understand, including new labor policies, technology systems, and signage requirements. This webinar is sponsored by Location Tech, a cutting-edge provider of panic button technology and systems in Southern California. Hirschfeld Kraemer, a long-respected leader in hospitality, labor, and employee law in California. And Tower Street Insurance and Risk Management, with extensive experience in commercial insurance for the hospitality industry. Our hosts for today's webinar are Keith Grossman, partner with Hirschfeld Kraemer and highly respected labor and employment law expert, and Jeff Engel, CEO of Location Tech, a panic button technology expert and retired Navy SEAL. Welcome, gentlemen.
Good morning.
Good morning.
This webinar is being recorded, and a link of it will be shared with all the attendees after the event. The slideshow presentation will also be available for download. If you have a question during the webinar, at the bottom right, you can click the activities icon, which looks like a triangle, square, and circle grouped together, and then you'll select questions. At the bottom right, you'll then select ask a question. You enter your question and click post. And also, if you would like to post anonymously, you can check the option post anonymously. Questions will be addressed live when possible, or during the Q&A session at the end of the webinar as time permits. So let's get started. Keith Grossman, please take us through and summarize the many topics of this new ordinance. Take it away, Keith.
Thanks, David, and thanks everyone for taking time out of your busy days to spend about 40 minutes with us as we work our way through this ordinance. So how did we get here with this confusing, predatory hotel ordinance? The story starts about 15 years ago with the passage of the LAX corridor, hotel worker minimum wage, quickly followed a few years later by the LA citywide hotel worker minimum wage ordinance. The LA ordinance that we're talking about today, as well as another one that just was passed by the city of Glendale, are the latest chapters of efforts by Unite Here Local 11, the union that's most relevant to our industry here in Los Angeles. The union's attempts to leverage their strong contacts and influence in local government to pass legislation that would, in theory, at least from their perspective, compel hotels to sign car check neutrality agreements, meaning that hotels would become unionized hotels. So after passing the LAX corridor statute for hotels, the LA minimum wage ordinance, the union was not successful in obtaining car check agreements, and instead it ratcheted things up and passed similar predatory legislation in Long Beach, Santa Monica, West Hollywood, and has a current ballot initiative pending in Laguna Beach. LA is just one more chapter, as I said, in passing. Notwithstanding all these local ordinances, not a single hotel that I'm aware of, at least, has come to the union and said, let's go sign a card check agreement because I can't take the pressure and the costs of these ordinances any further. The question I have is, will this new LA ordinance tip the scales and pressure hotels to sign card check agreements? So what is covered? Who's covered by the new LA ordinance? In general, virtually every hotel of every size is covered. This includes hotels, motels, apartment hotels, and extended stay hotels. Notwithstanding that general applicability, there are significant provisions that are only applicable to hotels with 45 or more guest rooms. And those are the housekeeping workload restrictions and the restrictions on mandatory daily overtime. In terms of who's not covered, the list is short. It's licensed bed and breakfast within a single unit residence, corporate housing, and short-term rentals like Airbnb. When does the law take effect? Well, given the way the city council took this ballot initiative out of the hands of Los Angeles residents and passed it right away, we don't have a lot of time to gain compliance. The ordinance takes effect on August 12th. Right now, there are no enabling regulations. As we'll talk about in a few minutes, there are a number of ambiguities created by the language of the ordinance, and how each hotel decides to interpret those will be a function of how much risk each hotel is prepared to take until we get some clear guidance from regulations issued by the city. As far as when, we hope soon, but personally, I don't think we'll see formal regulations out before the August 12th date that the ordinance takes effect. So at a 50,000 foot level, we'll cover some of these in greater detail. What does the ordinance require? A significant part of the ordinance relates to security, and that's mandatory distribution of panic buttons, personal safety devices. We'll talk about that in a bit. Another onerous provision are the square footage limitations for housekeepers. Square footage limits on a daily basis for each room, but it is limited to housekeepers. There's also, for hotel employees generally, a limit on overtime of up to 10 hours in a workday. Anything over that requires employee consent. There is a specific requirement mandating daily room cleaning, even for stayover guests, and an attendant, what I call Gag Order. We'll talk about that too. Training, there's detailed training requirements for the provisions of this ordinance, employee rights, details relating to panic buttons, and the way the hotel implements its SOPs relating to panic buttons. There also are detailed record keeping requirements. Most of those relate to the housekeeping workload provisions and the tracking of overtime and overtime waivers. All hotels also must provide notice to all employees of their rights under the ordinance. This is separate and apart from the training. For current employees, on or before the effective date of the ordinance, August 12th, hotels must provide employees with notice of their rights. For any new hires, those rights need to be explained upon hiring. And the last provision of this ordinance is a reduction in, or an increase in, the applicability of the LA hotel minimum wage. Until this ordinance was passed, the threshold was 150 rooms. Any hotel with 150 rooms or more had to comply with the minimum wage requirements for hotels in the city of LA. Under this ordinance now, hotels as small as 60 rooms will need to comply with the hotel minimum wage. A significant piece of the ordinance relates to panic buttons. And panic buttons need to be provided to all hotel workers assigned to a guest room or a restroom where other workers are not assigned to be present. I suggest that hotels think broadly beyond just housekeepers. The statute makes clear that the requirement applies beyond to all hotel workers, not just limited to housekeepers. So think about public area housekeepers who are alone in a guest room, engineers who might be alone in a guest room, room service servers. For smaller hotels, there may be managers who make deliveries to guest rooms and are there alone. Each of those individuals need to be issued a panic button. And a panic button, we know what it is and what it isn't, in large part by the terms of the ordinance. We know a whistle or a noisemaker is not a panic button. Panic button needs to be a portable emergency contact device. It has to have location tracking, and it needs to be able to facilitate communication between the housekeeper and the staff that's responding. The most important piece is that it needs to be able to signal where the worker's location is so that security or the trained designated supervisor can quickly find the individual who triggered the alert. In terms of who must be the respondor, that will depend on the size of your hotel. For hotels with 60 or more rooms, the alert needs to go to a designated assigned security guard who can respond immediately on scene. So let's break that down. That means that hotels of 60 or more rooms need to have security. They need to be on site. Now, it seems based on the language of the ordinance that you can either have proprietary security, i.e. security that you employ, or you can use a third party. However, the guard that you retain from the third party needs to be designated as the individual to receive reports of the panic button and needs to be on site and prepared to respond immediately. For hotels with fewer than 60 rooms, the report can go, you can have security, but it can go to a designated and assigned manager or supervisor. But that manager or supervisor can't have other responsibilities that would detract him or her from responding to panic button alerts. So the person has to be specifically assigned, you're the manager who has this responsibility, and they're designated. Even more importantly, if the hotel decides that you're going to use, instead of security, a supervisor or manager, there is a specific provision in the ordinance that requires 3 hours of training, and the topics that need to be trained on are delineated in the ordinance as well. For any employee, any hotel worker that triggers a panic button because of a perceived threat or violent conduct or observation of violent conduct, the ordinance requires the hotel to immediately provide paid time off so that individual can go see a counselor. Counselor is not defined. We hope that'll be something that is defined in the enabling regulations. In addition, that individual should be allowed and should not at all be discouraged from making a report to law enforcement. if the individual does not want to make a report to law enforcement, the hotel certainly can call 911. It just can't compel the individual who made the report to make a complaint or speak to law enforcement. The important thing is you can't discourage, you can encourage, but you can't compel the employee to participate with law enforcement. A significant provision in the ordinance is that there can't be any retaliation. Can't retaliate against anyone who triggers a panic button in good faith. And again, for either speaking to law enforcement or not speaking to law enforcement. The other requirement is that if an employee who is a victim of violence or threats and requests a reasonable accommodation, then the hotel needs to reasonably accommodate, whether that's a temporary shift change, temporary change in responsibilities. Those are things that you would consider. You probably would have an obligation, even absent the ordinance under the ADA or the California Family Rights Act, but the same sort of iterative dialogue and reasonable accommodation would be required here to somebody who has been a victim and required and ended up triggering a panic button alert. As far as training, the ordinance requires annual training for all employees on how to use a panic button, how it functions, and then the hotel's standard operating procedures. So what's going to happen in response, who's going to respond, and then details about employees' rights, the things I just covered. One thing before I kick it over to Jeff that I wanted to mention, we've learned that some of the better technology, such as that provided by Location Tech, will often result in a reduction in a hotel's, especially GL insurance rates.
Okay, and with that, since panic buttons are such a new technology and there are options on the market of differing qualities and coverage, we wanted to have Jeff Engel with Location Tech explain to us a little bit about panic buttons, how they work, and the differences in the technologies. Jeff?
Yeah, Keith, great information so far, and David, thanks for the intro. So to some extent, the alerting devices have been around for a while. And if you think about, there's kind of three different levels. There's two-dimensional, which is what you get, or 2D, what you get with your phone. When you push a button on your Android or your iPhone, you're getting two-dimensional, which means you know where you are from a bird's eye view. And then kind of the next phase or next generation is 3D location, but you're getting blind spots. And what 3D location is, it gives you the X, Y, Z axis, so you know what floor you're on. So not only where you are, like kind of what room you're in, if you're in 101 or 102 or 103, but also if you're on the first floor or the third floor or fourth floor. The part of the second generation or majority of the solutions that are out there, they have blind spots in them. And a blind spot, for the clarification, is just like when you're driving and you're on your cell phone, hands-free of course, but you're driving and your phone drops, or you go through a zone where you can't get cellular coverage. That's what have by blind spots. Because of the way buildings are designed and they're just building materials, many of them have blind spots. And so when you're looking at your solution, you want to make sure not only does it give you three-dimensionality, but also is it blind spot free, and is it accurate, or can it be tuned to be accurate to give you the accurate location, right room, right location once a button is pushed.
And Jeff, for a hotel that's looking to purchase a panic button solution, is there any way they can tell if they have blind spots or not? I mean, is blind spots based on the device or based on the coverage? And what is that kind of coverage? What kind of service?
Yeah, I don't know if I should grimace or groan on this one, because customers really don't know until you kind of say it. The way to figure it out is go look at the contract. when you look at the contract that they are asking you to sign, is how many caveats do they put in there saying they won't cover it, and that's how you can tell if someone really trusts their solution. But it's in every one of our installs, out of about 80% of our installs have blind spots in them. We have a customer that has a stairwell. They couldn't get cellular wireless coverage in it, and we have coverage in that, so they know exactly where they are on the stairwell, what level in the stairwell. So unfortunately, it's not crystal clear unless you do a heat map analysis, and the average person's not going to be able to figure it out. But the way for a customer to look at is to ask to look at everyone's contracts. And in a contract will, but most people aren't going to look at the fine print, but it's in the fine print. So when, first, I hope that answers your question, David.
It did, yeah. Thanks a lot. I think the technology behind blind spots you're probably going to go into a bit on this slide.
Yeah. So when you can do a solution that just solves the particular problem as a point solution, or you can have a solution that allows you to add on as you need. So if you look at the upper right, panic buttons, which is what this mandate's about, where this is doing. But once you install this blind spot free wireless network that it covers your entire building or campus or with multiple buildings, you can add these different use cases in as you need. So if you have a problem, and so if you have a problem with leak detection, with water, with guests leaving bathrooms flooding, you can add leak detection. But because you already have the wireless network installed, it's very easy to add these pieces. So the mandate is requiring you to do these and to put a panic button in so you don't have a choice. What you end up doing later on, and every property is different, is you start adding use cases where the ROI pays back in less than 2 months. And that's what we've done with our current customers. So for water leak detection, another one has temperature monitoring for their refrigeration systems. Another one has security guards. So they're doing tour management or tour document systems. So they can make sure the security guards are doing their rounds during the middle of the night. And that system tracks the security guard, which is different than the hotel worker being tracked, because the hotel worker is invisible until they trigger for help. And so it's the complexities behind the system for not only having a blind spot free, but being able to add these different use cases in once you get the platform in. So everyone who's doing this has to do this. Consider what you can do beyond that. And by the way, you don't have to add anything later on, but with this you can, and you can pick and choose what's going to save you money down the road. Dave, do you have any questions at this point?
Yeah. So if I'm understanding right, there are some blind or panic button solutions that are going to just work with my existing Wi-Fi network in my hotel, but then those might have blind spots and I might not know about it until somebody tries to trigger a panic button alert and it doesn't come through. And then there's other solutions like what you're saying yours provides, which is an additional wireless network you guys install. Is that right?
Yeah, correct. We install a network that puts an umbrella over the entire property, and then once you have the blind, and part of the installation process is verifying that it is blind spot free. And so, which brings a good point. All the systems that are self-install have no verification process whatsoever. So part of the install process, and this is any of our competitors and ourselves that are doing the install themselves will say this is part of the process, or they should be doing this, is to verify that it's blind spot free and you have complete coverage.
Okay, got it. Yeah, that's helpful. Thanks, Jeff. Okay, let's move on now. We're going to go on back to Keith to explain about notices on the backs of guest room and restroom doors.
Great. One other requirement of this ordinance that we hadn't touched on previously was a requirement that there be a specific notice on the back of each and every guest room and restroom door. Significantly, the ordinance specifies the font size, and the very specific message that needs to be on each of these notices. I'd caution against freelancing. Better to just stick to the language. And Jeff, I know as part of his team's installs, They are very familiar with this ordinance and can help to make sure that you've got the right notices to put on the backs of all your guest room and restroom doors. So what I think is the most onerous, the most costly, and the most troubling of all of the provisions in this hotel ordinance are the housekeeping workload restrictions. In essence, what the ordinance creates is a double time penalty. So hotels that allow their housekeepers to exceed the daily square footage limits must pay their housekeepers double time for all hours worked in a work day. Hotels with 45 to 60 guest rooms have a threshold of 4,000 square feet a day. Anything that exceeds that triggers the double time penalty. For hotels with 60 or more guest rooms, the limit is lower. It's 3,500 square feet a day. Now, if that wasn't challenging enough, there are other provisions that immediately trigger additional 500 square foot square foot reductions for cleaning. One is any combination of either 6 checkout rooms or what the statute says is additional rooms. And when they say additional rooms, what they really are referring to are rooms with rollaways and cots that are not normally in the room. One thing I should add as well, that in addition to a checkout room, the ordinance also provides that when a guest passes on daily housekeeping by putting a D&D, for example, on the door, that also is considered, it's not considered checkout, it's considered a special cleaning room, which means that it gets counted with that 6 threshold. So for example, if a housekeeper was assigned 5 checkout rooms and an additional room that had a D&D the previous day for a total of 6, that would amount to a reduction of 500 square feet. So in a hotel with 60 or more guest rooms, that housekeeper would then be limited to 3,000 square feet. And it goes up from there. So if you have assigned a housekeeper or they clean rooms that have 4 checkouts and 3 with rollaways or cots, that's a total of 7. That is a reduction of 1,000 square feet. So at the same size hotel, that housekeeper would be limited to 2,500 square feet in that workday. One open question that we hope will be clarified by the regulations is where you have 6 checkout rooms, and in that 6th checkout room, there is a rollaway or cot. Right now, the safer way to go is to reduce by 1,000 square feet, but there's some thinking that the regulations that ultimately come out will say that that's only a 500 square foot reduction. So again, until the regs are out, it's a matter of the hotel's risk tolerance. The other ways that square footage requirements are reduced by 500 square feet, if a housekeeper is required to clean in more than one building or is required to clean on more than 2 floors, you also reduce by 500 square feet. There's also a prorating provision. What that means is if a housekeeper is assigned to work less than 8 hours in a day, or in fact clocks out early, works less than 8 hours in a day, the amount of square footage needs to be prorated down. One of the small bones that is in this ordinance, there's also a proration up. So if an employee works 10 hours and is normally scheduled for an 8-hour workday, that 2 extra hours, that 25%, can be added on to the square footage total. One important open question, again, that we hope gets clarification from the city is, what is the impact of paid meal periods and rest breaks? Certainly, a housekeeper is not cleaning a room or assigned to clean a room during a meal period or during a rest break. So the open question is, should the square footage provisions be prorated down even for paid meal periods and rest periods? I think that's overly conservative. I think what's going to come out of the city is that you don't prorate down, and that as long as the meal period is paid and the housekeeper gets their rest breaks, if that is a full 8-hour schedule, 8 hours of pay, and there's a full board, then I think you will not need to prorate down. But this is space that we need to keep an eye on.
Okay, Keith, and then there's some questions that have come in. This might be a good
Sure.
time to interject with them now. Manny asks, can we have arbitration signed?
So you can have a signed arbitration agreement. I would suggest that, given the current state of play in California, I don't want to go too off topic, but there was a Supreme Court case, Viking River, that came out within the past few weeks that allowed for arbitration provisions covering PAGA claims. There's a statute in California that has been enjoined in part, prohibiting arbitration agreements. We still counsel, and I would suggest that you include an arbitration provision. It will not prevent or eliminate the obligation to comply with this ordinance, but if you include a class waiver, it might help from having multiple claims litigated in a single, with a single complaint. My suggestion is you check with your in-house counsel or your local counsel.
Okay, thanks for that, Keith. And then Dennis asks, 3,500 square footage, approximately 11 rooms. How many checkouts and how many stayovers?
So stayovers, if you had a full board of just stayovers and you're 60 rooms or more, it's 3,500 square feet. If you're 45 to 60 rooms, it's 4,000 square feet. In terms of checkouts, if you have 3 checkouts, that doesn't matter. That won't impact those square footage limits. It's only when the combination of checkouts, stayovers where the room is not cleaned, and rollaways or cots that total 6, where you'd reduce by 500 square feet. So if you have regular stayover guests, that only is an issue if they have put on a D&D and have passed on daily housekeeping for one day, and the housekeeper is now cleaning that room that hadn't been cleaned the day before.
Okay, great. And then one more question right now, and then we'll move on. Gretchen asks, I understood that if a stayover room had no service the day before, is it considered a checkout?
So the answer is it's not necessarily a checkout, but it's counted just the same. It's a special cleaning room that goes into that 6 threshold. So as I just explained, any combination of 6 checkouts or a passing on daily cleaning, stayover, or a room with rollaway or a cot.
Okay, great. Let's move on then.
So one of the more offensive parts of this ordinance, I think, are the interference with a hotel's ability to communicate with its guests. And that comes out of the ordinance's daily room cleaning mandate and also what I call the gag order. So hotels are no longer allowed to offer any kind of financial incentives to guests to pass on daily cleaning. So no free breakfast, no points, no incentives to pass on daily room cleaning. And then there's the part that I find troubling, which is the gag order. So hotels are not allowed to solicit guests to pass on daily housekeeping. It's unclear what solicitation means. You can look it up in Webster's, but until there are regulations, we don't know. Based on what the union has asked for during bargaining in some situations, we know what the union thinks. The union thinks solicitation means your front desk people can't even ask a guest as to whether they want to pass on daily housekeeping. You can't charge for daily housekeeping. The only way that a guest can indicate his or her desire for passing on room cleaning is to put a D&D on the door, or to call the front desk sua sponte and say, I don't want housekeeping today. So how can hotels get out of this? It's not easy, if not impossible. One way is basically you have to plead poverty. So you have to file an application with the city requesting a waiver. And then the basis are, if I comply, I'm going to file bankruptcy, I'll have to shut the hotel, or I'll have to reduce staff by 20%. Or reduce employees' hours by 30%. So it's a really high threshold. The only other way to get out of this ordinance is by meeting the union's wishes, which is to execute a collective bargaining agreement with an express, clear, and unambiguous written waiver. And for those hotels who are already unionized, just because you have a collective bargaining agreement doesn't take you out of the requirements of this ordinance. You have to comply with your collective bargaining agreement and your ordinance and the ordinance provisions unless you get the union to give you that written waiver. And there are good reasons to ensure compliance. The remedies are significant. For those of you who've had the misfortune of having a PAGA claim, the penalty provisions under this LA ordinance are similar, and they add up and aggregate really quickly. So it's $100 per day per aggrieved employee. So if you have a large enough workforce and there's multiple violations, it can add up very quickly. There is a daily cap for the record keeping portions of the statute, but it's still $1,000 a day. And again, that adds up quickly. The other added expense is if an employee retains a private attorney, and there is a private right of action under this ordinance, the hotel would have to pay that employee's attorney's fees and costs. For any willful violation, the damages are tripled. Treble damages. And lastly, for hotels hoping that the cavalry comes riding in from AHNLA or CHNLA or the Hotel Association of Los Angeles bringing a legal challenge, for a variety of reasons, I think the legal challenge in the current environment is unlikely, and you've got compliance obligations starting on August 12th. You should assume that you'll have to fully comply and be ready to comply starting on August 12th.
Okay, with that, we're going to move into the Q&A portion of the webinar. I'm going to go now to some of the questions that attendees have been sending in. Next, we're going to go to Riula, who asks, an RA has 4,000 square feet and finished cleaning in 6 hours. Can she perform other tasks like helping out the laundry and complete 8 hours?
So there are really two parts to that question. The first is if an employee is assigned and the expectation is that they've been assigned a board that will take 8 hours, then no proration is needed as long as that employee doesn't clock out early. If this employee happens to finish his or her board in 6 hours, yes, you should assign other non-cleaning duties. They can be assigned to fold laundry. They can, if they're capable of working at the front desk, they can work at the front desk. What they can't do is other cleaning. They certainly can't go clean another room, but they also can't go clean a meeting room. They can't vacuum the hallway. They can't do public area housekeeping cleaning, but any other tasks that you can assign them, you can and should assign. The other alternative, again, you don't want them punching out before 8 hours because otherwise you have to prorate down the square footage and you may back into a violation. So you'll have to have a policy in place that requires the employee to go sit in the cafeteria break room for 2 hours doing nothing, getting paid, but that 2 hours of regular pay is a lot cheaper than 6 hours at double time.
Okay, the next question comes from Sue. If my employee goes over the square footage by the 8th hour, can I prorate up by adding prorated square footage and pay just time and a half for an additional hour?
So if you assign the normal square footage, the 3,500 square feet in the 8-hour day, that's fine. If the employee took longer to complete the 3,500 square feet, then that 8.5 hours, that half hour is time and a half, as long as they don't exceed the 3,500 square feet. Now, if you're over, if that employee is over by a little bit, the 3,500 square feet, you can have assign the employee an extra hour or whatever it is to prorate up to come within the actual amount of square footage that person did. The period from 8 hours up, obviously under California law, would be at time and a half. So yes, you could do that. I wouldn't do that as a matter of course, probably, unless you go to a regular assigned 9-hour day or 10-hour day. It's unclear what the retaliation provisions, how they'll be construed. So I'd worry about manipulating that on a daily basis as opposed to just assigning 9 hours or 10 hours and having the fixed proration.
Okay, and then Manny has a question. What if our area there has no security guard service?
Well, you either have to hire somebody that and then send that person to be licensed or trained as a security guard, or you have to find one. In my experience, and I spent almost 18 years in the hospitality industry, I've never had a location where I couldn't find a security guard. Sometimes the local law enforcement will have off-duty officers available who you could use on their off day. But if there is a challenge in your area, certainly you can you can reach out to me after the seminar, and I have relationships with people in the industry, and I would be surprised if we couldn't find someone to assist in your area.
Okay, great. Well, that wraps up all of our Q&A session. And one last comment from Gretchen. Gretchen goes, ugh, which I think is the sentiment a lot of people are feeling with this new ordinance. Thank you, City of Los Angeles. Well, this concludes our webinar. Again, we'd like to thank Keith Grossman, partner with Hirschfeld Kraemer, Jeff Engel with Location Tech for hosting today and giving us insight into the legal ramifications and regulations of the ordinance and the technology requirements behind the ordinance. And then if you have questions related to employment law, labor issues related to this ordinance or in general for your property, you can refer them to Keith Grossman. His contact information with Hirschfeld Kraemer is up on the screen now. If you have questions regarding panic buttons, which solution is right for you, how you can understand the differences and the different kinds of solutions that are out there and what the cost of these are and how it's going to work for you now and in the future, refer those questions to Jeff Engel with Location Tech. His contact information is up on the screen. And then if you have questions around how your panic button solutions can actually affect or possibly lower your insurance, please contact Shaq Heaps with Tower Street Insurance. His contact information is on the screen as well too. Thank you everyone for joining us today. Again, the recording of this webinar will be sent out through an email link so you can watch it in its entirety again, as well as the presentation slides that we've been following along. Those will also be available for download. Thanks again to our hosts, and I hope everyone has a great afternoon.